Good morning. I am Sean Meehan with Bloomberg Law. I'm pleased to welcome you to a Supreme Court argument briefing co-sponsored by Bloomberg Law and SCOTUSblog. We are approaching the 2-year anniversary of the Patient Protection and Affordable Care Act. Since the President signed that act into law, it has been challenged numerous times, culminating in a case now before the Supreme Court. This morning, we hope to explore some of the arguments underpinning that case. I now have the distinct honor of introducing Lyle Denniston of SCOTUSblog. Lyle has been covering the Supreme Court for 54 of his 64 years in journalism. In that time, he has covered 1/4 of all of the justices ever to sit on the court and has reported on the entire careers on the bench of 10 of those justices. It's also to be noted that he is not an attorney. But Lyle is the author of The Reporter and the Law, Techniques of Covering the Courts. It's published by Columbia University Press, and it is still available. So I'd like to welcome Lyle.
Good morning, everyone. On behalf of SCOTUSblog and Bloomberg Law, we're glad you're here. If you weren't here, we wouldn't be. Contrary to the perceptions of some of my colleagues in the press room, I was not around when the Steamboat Monopoly case was decided, beginning the exploration of the Commerce Clause. And I would note that that was one case in which Paul Clement did not appear. I was, however, not very far behind when Theodore Roosevelt began exploring the possibility of a national health care law in the early 1900s. I came along just a little bit after that. My task here this morning is not to discuss the substance of the case, but to give you some outlines of the logistics of what's going to be happening in the next 6 to 8 weeks. First of all, I wanted to tell you what has been settled about the logistics, what is almost settled, and what is not yet settled. The first thing that I would tell you for sure is settled is that Justices Kagan and Thomas will participate in the case. There have been repeated discussions about whether one or both of them should disqualify themselves. There is one brief in the case urging Justice Kagan to recuse, but there have been multiple opportunities for either one or the other of them to recuse, and they have not yet done so, and I think it's pretty clear that they will continue to participate. I think it is also settled that there will not be any live television coverage of the oral arguments in late March. There is a request that that be done, but I don't think that there's any possibility that there will be live coverage. One other thing that is definitely settled is that the court has completed the briefing schedule, though not all of the briefs are in yet. I did a count last night in the press room. There are 93 amici briefs, including one by Bob Long, who's going to be arguing the anti-injunction case issue in the case. And there are 11 briefs on behalf of the parties. There are still more briefs to come in, including tomorrow. I think Bart Farr's brief is due tomorrow on the severability question. Some issues that are not yet but are almost settled is how much time there will be for oral argument. The court has already committed to 5.5 hours, but the parties have asked for another half hour on the Anti-Injunction Act issue, and we presume we will see an order from the court acting upon the competing allocation of time requests. There probably also will not be a same-day release of the audio tapes made of the oral argument. The current Chief Justice has a policy that he prefers not to release any audio tapes on the same day of the hearing. So now the common practice is to release all of a week's audio tapes on the Friday following argument, when only historians and weekly magazine editors and maybe counsel have an interest. The daily press simply has lost interest by that time. There could, however, be a change in that policy for this case, but I personally don't look for it. I think the court has already made one or two gestures to indicate that it treats this case differently than others. For example, the court has some of the filings in the case posted on its website. The court also has set aside 5.5 hours of argument for this case, and normally there's only 1 hour of argument. I would, just to my friends in the press, I would urge you not to overlook too quickly the Anti-Injunction Act issue. This is one of those issues that for the mainstream press, it tends to fog over the vision. However, this is a very critical issue in this case, and your readers need to know about this as much as they need to know about the mandate. I would also just like to tick off a few issues that are not before the court, and perhaps most importantly, the birth control mandate is not at issue before the court now. If you wish to see where that currently stands as a legal matter, the Federal Register yesterday published the regulation, the final regulation on what the administration intends to do about that. But there are still negotiations over how to implement the part of the mandate that will require insurance companies to provide contraceptive care at no cost to the employees. I would also mention that one other perhaps major issue that is not before the court is the employer mandate. That's the employer equivalent of the individual mandate. That was raised in some of the petitions for review, but the court opted not to do that. It has been suggested that perhaps I should offer a prediction as to how it will come out. I'm not going to do that. I am not in the business of making predictions, except that the following panel will be very, very informative. Thank you very much.
Thanks so much. My name's Tom Goldstein. I'm the publisher of SCOTUSblog. We're incredibly grateful that those of you in the room and those of you watching either streaming or through C-SPAN are taking the time to be with us. Everybody understands, I think, the significance of the case that the justices are about to hear on the Patient Protection Act, both with respect to the fate of healthcare reform and also for the fate of the structure of the government. There are incredibly well-meaning and concerned people on both sides of the case. One small point of personal privilege is I have a dog in this fight as a lawyer in an amicus brief, and want to make clear that my job here has nothing to do with that. It's simply to facilitate the discussion of the folks who are going to do the talking. And I want to introduce them. We have produced a media guide for the folks who are here, and you can find their bios at the back, links to the bios at the back of that. But let me just, so that we can move quickly to the substance, give you a little bit of background about each of them. Paul Clement is the former Solicitor General of the United States. He's the principal lawyer representing the state plaintiffs in the case. Roughly half the states have sued to challenge the constitutionality of this statute. He has the distinction of arguing every case in the Supreme Court this term, or nearly so. Depending on how many cases you count this as, you could count it as at least 10 oral arguments in the Supreme Court this term. I think widely regarded as the most distinguished and best lawyer of his generation. Michael Carvin is a partner at, and Paul's a partner at Bancroft. Michael Carvin is a partner at Jones Day. He is the former deputy head of the Civil Rights Division, the former deputy head of the Office of Legal Counsel in the Department of Justice, is the principal lawyer for the private plaintiffs has been involved from the very beginning in formulating the legal theory and strategy in the case, has been involved in a massive amount of litigation, is really regarded, I think, as perhaps the best legal thinker in litigation involving the business community and a lot of conservative issues. To my left is Neal Katyal. He's the former acting Solicitor General of the United States. He argued most of the cases in the courts of appeals as this question was being litigated against the United States. He is now co-head of the Appellate and Supreme Court practice at Hogan Lovells, which is an international law firm. Is regarded as, at the very least, among, since I guess he and Paul are the same generation, is the leading Democratic lawyer of his generation. Akhil Amar is a professor at Yale University. He teaches both in the law school and in the undergraduate college with a specialty in both constitutional law and constitutional criminal procedure. Regarded, I think, fairly as one of the 5 most distinguished legal thinkers in America today, and in particular, in my own view, at the very least, a legal thinker in academia who's, rather than gravitating towards kind of the esoteric and incomprehensible, actually gravitating towards the important and the clear, and has written and spoken at great length about the healthcare litigation. We are here, obviously, with the purpose of talking about the case as a whole, but in the time that we have available, our goal is to focus on what we regard as the heart of the case, which is the challenge to the individual mandate. We'll have a question period at the end, and if folks want to ask about another part of the case, they're more than welcome to do so. It has been suggested by the justices of the Supreme Court that you could talk about this for 5.5 hours. We have less than that, so we're going to focus right on the core of it. I have really encouraged the panelists to engage each other, to not hold back. None of them are known as shrinking violets. I don't think this is going to be a problem. But to really cut to the heart of the matter and what the essential arguments are about the constitutionality of the individual mandate. I want to start, if I could, because we haven't, a lot of folks in this room know a ton about the case. A lot of folks in the room won't know as much about it, and a lot of the people watching it elsewhere won't know a lot about it. So if I could just ask Paul Clement to, in a sense, set the table with a brief description of what the individual mandate is and what the heart of the constitutional challenge is.
Sure, I'll give it a try. I think maybe Neal would have a different way of describing it, but probably not too different. The key provision here that has generated the most controversy and the central constitutional issue that we're here to discuss is the individual mandate, which essentially requires, with 1 or 2 minor qualifications, every individual in the country to obtain qualifying health care insurance. And this is something that certainly the framers of the Act, when they were putting it together, thought was critical. They'd looked at some states that had tried to do other insurance reforms, including trying to make sure that insurance was available generally to everybody and that you wouldn't be denied insurance because you had a high-risk condition. States that had tried that without an individual mandate had run into problems. At least one state, Massachusetts, had tried it with an individual mandate, and it was perceived as being more successful, so it was perceived that the individual mandate was quite critical. I don't think it was perceived by everybody that was the only way to accomplish adequate health care reform. There were earlier versions of the Act that kind of more affirmatively embraced the taxing power and the taxing authority, but in the end, it was settled that the Health Care Act would pass and it would include this individual mandate. What I think gives rise to the central constitutional issue is the starting observation that this was really a fairly unique or completely unique, depending on your perspective, provision of law. There have been a lot of crises in this country over the years, that economic, other, where Congress might have thought that forcing individuals to purchase a particular good or a particular service might be a useful means of government action, but the government never did it. I mean, just to take an example, that has always resonated with me because it's so recent and it seems to me so obvious that a compelled purchase would have been an even more effective regulation. There was the famous Cash for Clunkers program involving a series of incentives to get people to help the car industry by giving them incentives to purchase cars. It seems to me it would have been much more efficient and effective for the government in accomplishing its objective of boosting the automobile industry to simply say that everybody over a certain income level just had to buy a car. Much more direct way to accomplish that objective. The government has never really seen fit, at least at the federal level, to do that kind of direct requirement that individuals engage in commerce. And so that's what really gives rise to the basic issue here, I think. You know, the government, the federal government on its behalf suggests that this is, although I think they concede that it's a largely unprecedented action, I think they suggest that it's a fairly straightforward regulation of commerce supported by the Commerce Clause. The challengers, on the other hand, point to both the unprecedented nature of the imposition and the government's seeming inability to articulate a limiting principle such that if you could engage in this regulation, what regulation couldn't the government engage in? What commerce couldn't they force you into in the name of better regulating commerce? So in a nutshell, I hope that's responsive, at least setting the table, and I'm sure I've said at least one thing that makes Neal want to clarify.
Just one. First of all, thank you for this wonderful event. It's a delight to be here with all of you. I'm here, I did represent the government. I'm obviously not here now representing the government. I'm just speaking for myself. And I agree with a large part of what Paul said in terms of the description, but let me just flesh out exactly what Congress was doing, because honestly, I didn't understand why this individual mandate existed until I started getting really into the weeds and arguing the case. So Congress was reacting to a problem in which there are approximately 50 million people who are uninsured in this country, and they're priced out of the insurance markets. And a large part of that has to do with discrimination against those with pre-existing conditions. That if you're in one job and you try and switch your job, you can't really do so because that other employer looks at you and says, oh boy, this person has all sorts of, this person has high risk and so on, and so the insurance costs for them are too high. So 50 million people approximately are uninsured. Congress comes along and says we're going to eliminate the discrimination against those with pre-existing conditions and insist that everyone be rated at a certain level in a community so that you can't stick the bill too high to particular individuals. Now the problem with that is once insurance companies are told, well, you've got to insure folks and at a fair cross-section of the rate, then everyone could just wait to buy insurance until they got sick. You'd wait until you got to the hospital before you had to sign up for insurance, and then that way you'd economize on your costs until you got sick. Well, that obviously would create massive adverse selection problems, and did in the states that tried to reform the insurance markets through pre-existing discrimination bans and the like. So what Congress did is they said, we're going to have an individual mandate so that everyone has to have a certain amount of insurance precisely to avoid that adverse selection problem. Right now, Congress found approximately every American family spends about $1,000. Every American family who gets health insurance pays approximately $1,000 extra to pay for those who are uninsured, and those costs spread across state lines. And so that's really, I think, what Congress was saying when they said that this is part of their commerce power, that health care is approximately 18% of the GDP. And this is a comprehensive regulation of the health insurance markets. Now, Paul says that the example that resonates with him is that why didn't the government do this with respect to the automobile industry? The automobile industry is really different. I mean, that's not a situation in which you can show up at the car lot, drive off with a car, and stick your bill to your neighbor. That's what's going on in the health insurance market. That's what Congress found, that the uninsured are going into emergency rooms, and you and I, who are paying for health insurance, are effectively paying for them. And that is an economic effect that is real and present right now.
So, Michael, assuming you weren't persuaded by that, is health insurance kind of foundationally different in a way that explains why Congress could impose the mandate here but not in some other context?
No, Neal, as always, is wrong for 3 independent reasons. The first is he completely misdescribes Congress's purpose in enacting this plan, and this is not me speaking. This comes straight from the text of the statute. Neal and the government try and pretend that what we're trying to do is prevent the insured from subsidizing the uninsured. It's actually quite the opposite. What you're trying to do is conscript a lot of healthy individuals to come in and buy insurance before it makes any actuarial sense for them to do it. And the reason you're doing that is because you've required insurance companies to give insurance to all of these sick people. So you counterbalance that by bringing in a lot of healthy people who the insurance companies make a lot of money off. Again, this is not me talking. This is the Congressional Budget Office. It scored how much subsidy to insurance companies is coming in from the individual mandate. $28 to $39 billion a year. $1,200 per insured person is being reduced because you're taking a bunch of healthy 30-year-olds who have absolutely no need for insurance, except perhaps catastrophic insurance, which the Act quite cleverly prevents them from buying. The only people who would want, the only kind of insurance you'd want as a single 30-year-old is catastrophic insurance in case I get hit by a bus or something like that. And Congress in its wisdom says, no, you can't buy it. You've got to buy the contraceptives, the wellness programs, and all of these things that are going to do you a whole lot of good. And why do we do that? Because we want your insurance money to lower insurance premiums. So it factually is wrong. As to this adverse selection problem, it's also factually wrong. There's an 11-month waiting period, like everybody understands. You've got a certain opportunity to buy insurance. Well, what kind of person is going to sit there and say, gee, I really need insurance, I'm very risk averse, but I'm going to become a casino gambler because maybe during the 1 month in which I can buy my insurance, I will be able to, as he put it, buy insurance on the way to the emergency room. It's just a false tautology. Again, not me. CBO didn't score it. There wasn't an ounce of testimony, a line of testimony trying to document what cause this is for adverse selection. Second big point is, look, Neal and I can disagree about the policies and the economics and all this stuff, but what difference does it make? The court is not going to second-guess Congress's policy judgments about what is beneficial for commerce. They're courts. Congress is the one that makes the policy. So Neal and the Justice Department can come up with whatever policy differences they think are important and whatever unique aspects there is of health insurance, but once Congress has the ability to say that compelling commerce, compelling you to buy a product, is regulating commerce, there's no reason in the world it has to be limited to the unique healthcare context because Congress has the power. And once Congress has the power, the court defers to their policy judgment, and of course, that's the proper role. So while the government tries to jerry-build all these economic and policy reasons why allowing this case in this one context is not, is unique, what they can't do is articulate a constitutional principle that says once Congress has this power, they can't, for example, require you to buy a GM car for precisely the same reason. We impose all kinds of restrictions on the car companies, environmental safety regulations that drive up the cost of cars, just like the so-called non-discrimination provisions drive up the cost of insurance. If Congress is allowed to force strangers to these transactions to subsidize the companies that we've burdened with strong economic burdens, there's no reason in the world that they can't do it in the cash for clunker situation, just like they can do it in the healthcare context. So really, as everyone has pointed out, and as the Justice Department has been completely unable to show, there is no limiting principle. Congress has the power to compel purchase, to serve the public welfare, to improve commerce, game over. They can do it for banks, car companies, anyone else they want to.
So I do want to come back. I know you have a third point, but Akhil Amar, among your reactions, both Paul and Michael have said that there is no limiting principle here. Maybe there either is there one, or does it not matter that there is one, because this is within Congress's commerce power?
The most important decision that the Supreme Court ever issued on the scope of federal power is called McCulloch versus Maryland. If you take McCulloch seriously, everything that Michael and Paul said is clearly wrong. Clearly. Here's what John Marshall says in McCulloch versus Maryland. And by the way, the argument is, oh, well, this creates this bank, it's a corporation, and that's special, just like, oh, it's an individual mandate. And Marshall says, wrong, wrong, wrong. And he says it for reasons that are absolutely applicable here. Corporation, for example, Marshall says, has already been created under other clauses of the Constitution. Why not here? We actually have had individual mandates. George Washington signed his name to an individual mandate. It's called the Militia Act of 1792. And we had an individual mandate. I'll read you the language before the end of today. If you can have it for that, you can have it for the other thing. But here's what John Marshall says about the limiting principle. Oh, and by the way, can government tax me? Yes. Can it take that money and buy stuff with it? Yes. Can it, once it has bought something, can it give it to me? Yes. If it can do those three things as a matter of logic, why can't it say, buy it yourself, Amar? Cut the middleman out. And when either of them has a one-sentence or one-paragraph argument, counter-argument to a basic logical point, then we can start to take this seriously. But they don't, and government can tax me. And here's what John Marshall says about that. And it's about the limiting principle. McCulloch versus Maryland. The power of taxing the people and their property is essential to the very existence of government and may be legitimately exercised on the objects to which it is applicable to the utmost extent to which the government may choose to carry it. The only security against the abuse of this power is found in the structure of the government itself. In imposing a tax, the legislature acts upon its constituents. This is in general a sufficient security against erroneous and oppressive taxation. If you do not like this, vote the bums out. I personally don't much like many aspects of this law as a matter of policy. I personally would have preferred to see a lot of tort reform, malpractice reform in the thing. You know, my wife's a physician, and we've been sued in malpractice. My brother's a physician, and he's been sued. My mom's a physician, my dad's a physician. I don't like major portions of this as a matter of policy, and if you don't, vote them out. But we voted for President Obama and his party the last presidential election, and they said they were going to do this, and that's what they did. And if you don't like it, then we're going to have another presidential election on this. The security, the limiting principle is that they are taxing, in effect, us. They're making us pay. And if we don't like it, if we think we're not getting good deals, if they do a cash for clunkers, I don't think they will because there's no need for it. And we don't need constitutional lawyers and judges pulling principles out of thin air to limit the ability of Congress to pass silly laws on cash for clunkers, requiring you to buy a car. Congress won't do it and hasn't done it because there isn't a need for it. But if they do it, then I'd want to see why they did it, and there might be a reason for it, just as there was a reason to have an individual mandate in the Militia Act of 1792. Mike talked about conscription. Well, actually, the government can conscript you. You know, jury service is conscription, militia duty is conscription, and let me just read you the language of a law that George Washington signed his name to, in which every citizen shall, within 6 months, provide himself with a good musket or firelock, a sufficient bayonet and belt, 2 spare flints, and a knapsack, a pouch with a box therein to contain not less than 24 cartridges, and on and on and on. And Mike says, you know, you don't need, if you're 30 years old, a health insurance policy unless you're going to get hit by a truck, and they're subsidizing older folks. And I say, welcome to the Social Security Act, in which younger people might be, paying in for older people, and there's nothing unconstitutional about that unless we're going to, roll back 70 years of progressive legislation. And on conscription, and on whether you need it or not, the next attack may very well be biological, germ warfare, and what we need to prevent that is everyone's going to need vaccines. We're going to need herd immunity because viruses don't respect state lines. They don't stop at state lines. 200 years ago, national security meant everyone had to have a musket. Today, national security means everyone has to have vaccines, and they're more likely to get vaccines if they're required to have insurance so that they'll actually go and get the vaccine when they need it.
So what I wanted to do is I do want to make sure, so there are 2 arguable constitutional bases for the statute that have been discussed. So far, the three of you all talked about the Commerce Clause. And Akhil has put on the table that there is another power that could be used to justify the statute that's discussed by the government. It has blown a little bit hot and cold about it. But Paul, can you address the question of whether this is a tax, so that even if it weren't within Congress's Commerce Clause power, it's within its taxing power?
Sure, and in the process, I'm going to make a couple of points in response to Akhil, and Mike will probably supplement them. But there is this argument, and Akhil has alluded to it, that even if this isn't the individual mandate isn't valid under the power that Congress expressly said it was exercising, which is the commerce power, that it nonetheless might be supported by the exercise of congressional power that at least the President expressly said was not being used here, and that's the taxing power. And in some respects, I think the simplest answer to that argument and to Akhil's point about McCullough, which I embrace McCullough. I might just quote that passage in McCullough in my reply brief. Here's the thing. The simple reason why the mandate is not a tax is because it wasn't labeled as a tax. It doesn't operate the way that a normal tax does. It's clearly something different.
Well, can you just pause for a second? Because we haven't described how the tax does operate. So could you just...
Well, there is no tax.
Well, okay.
So what this does is the mandate is a requirement that every individual, save sort of people who are incarcerated, people who are Native Americans and have sort of a separate plan, and one or two others. Basically, everybody else has to get health insurance. Now, there is a separate provision, which is a penalty, that operates as a penalty against those who do not buy complying insurance. That penalty, which is a little closer to a tax than the mandate, doesn't apply to everybody to whom the mandate applies. It has a separate set of exemptions that are much broader. So there are a lot of people, for example, virtually all the low-income people, that are subject to the mandate. So they have a federal obligation to obtain complying health insurance, but they're not subject to the penalty if they don't. And the penalty does, like any penalty, has the capacity to raise some revenue, but it's not the principal focus of the challenge. It's not the mandate that really has everybody upset. So that's why I think you really need to focus on the mandate. And this gets to Akhil's point from McCullough. What the Chief Justice said in McCullough is that the taxing power is a broad power, and that once you have the government exercising its taxing power, there aren't going to be a lot of mechanisms for the court to limit that power and say this tax is too high, or this excise tax on this product is somehow impermissible. And all of that's fair, and that's why Chief Justice Marshall, wise man that he was, said the principal limit on the taxing power has to be structural and has to be essentially the people who are the taxpayers saying, look, we don't want any taxes. And of course, that's exactly what the people said at the time that this health care law was being debated. And it's precisely why, even though in earlier versions, Congress contemplated doing something quite similar by express use of the taxing power, and they backed away from it. The people did speak. It was, the Massachusetts election, among others, of Senator Scott Brown. And the people who passed this law in Congress knew full well that there weren't the votes to do this directly as a tax. So they used the mandate. Now, the mandate has effects that are similar to a tax. It avoided the tax label, which the President himself made clear was critical to get this thing passed, was to make it clear to everybody, this is not a tax. But as Michael alludes to, it really is a tax. It's a sneaky tax. It's not a tax that is on any group of people you would otherwise rationally say should be subject to a tax, like people who are high-income people or people who engage in certain transactions that are risky. All of that might make sense from a logical taxing policy. It taxes what I would think are people that you wouldn't logically really want to tax otherwise, which are reasonably healthy, reasonably young people who don't have a lot of spare income, and so they're inclined to maybe save their money by not buying a health insurance policy that they don't want. So it has a lot of the invidious aspects of a tax, but it doesn't have the one thing that Chief Justice Marshall said is critical for a tax, which is the kind of upfront accountability that allows the structural process of government to work. And so let me just finish by saying, Akhil said we could start a serious conversation if we had an answer for why this is different from just taxing people and then taking things from some people and giving them to others. And I think, I think that the short answer is, no, this is completely different from that for one way that's critically important, and that's accountability. There's a lot of accountability in taxing people. There's a lot of accountability in being very clear about who's getting the benefits of those taxes. What happened here is that a group of insurance companies who otherwise would have protested long and hard against the new impositions that are implicit in the health insurance reforms that Neal described, they were basically quieted because an effective tax and subsidy, sub silentio, was devised where they'd get all this money on the backs of relatively healthy individuals. And I think if you tried to do the same thing through taxes and subsidies, it wouldn't have happened. The act wouldn't have passed. And that's accountability in action.
Can I just begin by agreeing with Akhil? I mean, I absolutely agree with every word he said. His tautology is anything that Congress can tax and take and give to an individual, Congress can require one individual to pay for another. Since Congress can pay for somebody's insurance premiums through the tax dollars, then it can require you to pay for this person's insurance premiums. So we all agree there is no constitutional limiting principle. Once we give Congress the power to take property from A and give it to B, they can do it in any circumstances they deem advisable. And the only check we have against this is the honesty of the political process. So, for example, if somebody ran for president and said to Hillary Clinton in the Democratic primary, I'm absolutely opposed to an individual mandate, and if he promised each American that he's not going to raise taxes on anybody making less than $250,000 a year, he couldn't turn around and endorse an individual mandate and impose taxes on people making less than $250,000 a year. But the big difference, wholly apart from the honesty and accountability of our political process, is the tax system does apply to all Americans, or should. And if we want to accomplish social goods, if we want to conscript insurance companies and say, look, there's all these sick people out there, we know it's going to cost you a lot of money to insure them, but we need to do it for the greater societal good. Well, as the Supreme Court said in Armstrong, if you're forcing people to engage in a public good, the public as a whole should pay for it. That's how we've done it in all other circumstances. If we require hospitals to give service to poor people because of our normal charitable instincts in that regard, we give them a tax exemption, or we give them subsidies out of the federal fisc. That's all we're asking for here. If Congress wants to force one private citizen, i.e. insurance companies, to help other people for obvious charitable reasons, terrific. What you don't do is then not pay for it. You don't conscript some person who's not in any way responsible for the problems of either the insurance companies or the sick people and make that subset of the American citizenry take the entire tab. If we as a society think it's so important to give protections against insurance discrimination for pre-existing conditions, terrific. That's a policy choice that's open to us. But we've got to pay for it. You can't conscript somebody to say, I'm going to pay for this other person's insurance premiums.
So in contrast to my dear friend Paul, I think you can read McCulloch until you're blue in the face. You will never find the principle he's trying to tease out of that case, which is that Congress has to somehow say it's a tax in order to invoke the taxing power. Rather, the whole point of what Chief Justice Marshall and McCulloch is saying is that the great check against a lot of these hypotheticals that we're worried about is the political process generally. Now, with respect to the tax power itself, I don't think anyone was fooled that this was a tax. A constitutional point of order in the Senate, after all, was defeated in part on the ground that this was a tax and therefore constitutional. The way that the act works, if you don't sign up for health insurance, you have to report it on your 1040 tax form and pay a penalty. Every April 15th, you were reminded that this is a tax. And indeed, the way that the tax is calculated is it looks to a percentage of your adjusted gross income, and that's what you pay, which makes it look and smell very much like a tax. And indeed, Congress found it functions like a tax. It will raise money. And the CBO found that it will raise, I think, $19 billion a year in putting it in the federal coffers. So I think it's quite clearly within the heartland of the tax power. But I don't think Akhil's point about McCulloch is really about the tax power as much as it's about what is the real check in our government against these worries that my friends have pointed to. And I have to say, I grew up took law school in the early 1990s, and I thought the great conservative idea, was that the political process and not unelected judges was the way we get this stuff done. And I am struck by the change in the way the debate has unfolded over the last 10, 15 years, and it's now, striking legislation down after legislation as unconstitutional because they couldn't get their victories through the political process.
So, but I just would ask if, the challenge has been laid down by Paul and Michael on one very particular point. I just want to make sure whether we're agreed on it or not, and that is, they say that under the view of the defenders of the statute, there is no non-political limiting principle. That is, other than the significant, no doubt, ability to vote out the president and Congress and that sort of thing. There's nothing that you could go to a judge and say, this mandate is unconstitutional. Is that right or wrong?
No, I think that's absolutely wrong.
Okay,
so if I could could I flesh that out?
Sure.
Okay, so first,
Neal, I've got a thought on that.
First of all, I think it's important to appreciate the role of government lawyers, which Paul certainly does. The government's not going to come in and say, well, here are our limiting principles and foreclose a future Congress from something that they might decide is really necessary on all sorts of situations that we can't anticipate right now. And so the government's job is often to say, here's what the heartland of our claim is. Those cases are for down the road in a different thing. But if they wanted to, I think the limiting principles are fairly easy to articulate. The first one is, of course, the Bill of Rights cuts against any structural power in Article 1, Section 8. So, the example, can Congress force you to eat broccoli because broccoli will make you healthier and it'll reduce health care costs? Well, the right to privacy and so on will preclude the government from acting in that way. The second principle is that Lopez and Morrison themselves are limits. These are the Supreme Court's cases in 1995 and 2000 that restrain the ability of the government in the Commerce Clause area. Those are true limits, and I think the government takes them seriously. And the most important limiting principle that you can get out of those cases is this, that when Congress is acting to solve a truly national problem, that is one in which the states aren't separately competent to solve, that's when its power is at its apogee. So here, Congress found that when any individual state like Massachusetts tries to reform the health insurance markets, what happens is that the uninsured from other states will come in and swamp those insurance markets. And therefore, in the state knowing that, often will not enact legislation to deal with the problem because they don't want to become magnets for the uninsured. The only way to solve this health insurance crisis is a truly national solution.
Limiting principles. I read you a passage from McCulloch where he was talking about the tax power, but as Neal has said, there are other powers and the political constraints kick in there as well. So there are two different bases for why this is constitutional: taxation and interstate commerce. On taxation, they have to be right about both. We just have to be right about one or the other. I think we are right about both. And in fact, there are three at least different Commerce Clause arguments. But on tax, first of all, the Constitution doesn't use a magic word of tax. Sometimes it refers to taxes, sometimes duties, sometimes imposts, sometimes excises, sometimes revenue. That's, by the way, the word revenue is actually in the individual mandate section. It's part of Title 26, which is the Internal Revenue Code. It's enforced by the Internal Revenue Service. The CBO says it's going to raise $100 billion with a B overall. It's going to bend down the cost curve by $100 billion. It's going to be, revenue positive. That makes it like a tax, and the Constitution, I said, uses the word revenue. It is passed by the House and Senate under specific internal rules that only apply to revenue measures. And by the way, if you don't have to pay income taxes at all, the mandate doesn't apply. It's enforced on April 15th through the tax form and the tax code. And if you want to look at the word tax, if you think that's somehow important, because people aren't fooled on April 15th when they have to pay the thing. They understand it's a tax. The words taxable, tax, taxation, taxpayer appear 34 times in section 26 U.S.C. 5000A, which is the relevant section. Okay, so that's on a tax. And so what are the limits on that? It really has to be a revenue measure, and it is. And, and people will understand that. The political safeguards kick in on April 15th. They understand what this is. Now, on commerce, it has to actually regulate the act as a whole. Not each section, but the act as a whole has to really be trying to solve a problem of interstate commerce. It has to be an interstate spillover problem. There are several interstate spillover problems. One is the welfare magnet problem that Neal pointed out. Another is the lock-in problem. You have a job now. You're worth more to the economy somewhere else. They're willing to pay you more, but you can't go there because they don't want to pay your health care costs, which are going to have to be paid by the system somewhere anyway. So it's locking people in to their less, they're not their highest and best use. People are afraid to travel interstate. If they fall sick, you go into an emergency room, and if they don't pay for you, then you're not going to want to travel. And if they do pay for you, they're paying for out-of-staters. So at any given moment, what proportion of people are out of state? I don't know the answer, but I would suspect it's more than 3%, probably less than 30%. And when every Friday, I'm in New York. I live in Connecticut. If I fall sick, they're going to take me to a New York emergency room, and I hope to God they'll take care of me there. But New York is paying for a Connecticut person in that case, and that won't be fair unless I actually have insurance, because the New York taxpayers won't be paying for me as a Connecticut person. So you need to provide for emergency room care so that people will feel free to travel interstate, and you need, in order to do that, to make sure that people have insurance so that some states aren't taking advantage of other states, because it doesn't all even out. This individual mandate itself need not actually regulate interstate commerce. It just needs to be a part of a comprehensive scheme that as a whole regulates interstate commerce. That is what Justice Scalia very explicitly said in the Gonzalez versus Raich case, that you don't look at each prong of the law, you look at whether it actually the law as a whole tries to solve an interstate problem.
All right, so
well, boy, that really puts handcuffs on Congress, doesn't it? I mean, we've been listening to 20 minutes of this, and you know what Congress has got to do? It's got to rationally find that it's a problem, and the regulation doesn't have to do anything with commerce, but as long as you attach it to a bill that's got something to do with commerce, that's okay. Michael, and then Neal has said it's a national problem.
Michael,
come on.
Give it its due, and that give it its due, and that is, I think we can agree that healthcare affects interstate commerce, as does so many things under the modern conception of healthcare. It's not just attached to something. It is part of an integrated scheme. That doesn't make it constitutional, but is it fair? And obviously you think it is, but explain why it's right to say there's this bill that have 5 pieces that work together. One of them is an individual mandate, and so what we do is we assess the constitutionality of the individual mandate as opposed to the letting them get away with the statute as a whole. So
I think it's a really fair question, and I'm sure Michael has a great answer to it. I just like, before we leave completely the limiting principle, I mean, can I just say 2 things, which is, I mean, I'm not sure I really heard one, particularly, I mean, I think Akhil gave a great defense for why this statute would be, it was a great argument for why this statute might be in interstate commerce, but in doing so, he laid out an argument that I think would apply to almost every commodity, because as you said,
are the limiting principles.
But okay, but that and look, I argued race, and when I was asked for my limiting principle, I pointed to Lopez and Morrison. But that has nothing to do with this particular power, and this power is unique, which is the power to compel somebody into commerce to more efficiently regulate commerce, and that power is precisely what doesn't have a limiting principle. There's really no commerce that I can't force you to engage in on the theory that it would then be easier for the federal government to regulate the resulting commerce or the broader commerce
That
market.
is an argument by pun. The basis for the regulation is not the individual mandates. There's an interstate problem that pre-exists the individual mandate. This is one way to. So hang on. This is really important.
Maybe then we should transition to the question that Tom asked Mike, which is your point here, I think, is that that you don't have to show really anything about the interstate commerce, the individual mandate, as long as it's part of a broader regulatory structure that regulates commerce. And I think we certainly take issue with that.
And in your initial statement of the facts, twice you said not just a part, you said, quote, a critical part. We have the on each side.
I think Mike and I will.
It is a critical part of a comprehensive scheme plan to deal with a genuine interstate problem that no individual state can handle on its own.
Akhil,
and John Marshall would have had no problem with that.
You well know, every word you emphasized in that sentence, genuine interstate commerce, are the kind of words that the Supreme Court will always defer to Congress on. And so when Congress in this context says it's genuine, and in the next context, all caps, exclamation point, genuine, the court's going to defer. And that's why that's no limiting principle.
Interstate.
Interstate. Let's start there. I'm sitting at home in my living room. I'm not buying insurance. I'm not engaged in commerce, local, intrastate, interstate. So how can they force me to enter into the stream of commerce? This is not like Mr. Wickard or Filburn growing wheat, where he is producing a product that is indistinguishable from the interstate product and which greatly hampers Congress's ability to regulate the interstate commerce. How am I a problem when I make a perfectly sound economic decision not to buy insurance? What of the scheme have I screwed up? They keep saying this is an integral part of the scheme. They can still require insurance companies not to discriminate against people with pre-existing conditions if I don't buy insurance. Here's my role. I'm the solution to the cost problem that Congress has created. So every time Congress, as all regulation does, drives up the cost when you regulate a company, they can say, that's solving an interstate commerce problem. I don't want to pay for it with tax dollars. You, go solve my problem. Go buy a car from GM. Go buy broccoli. Maybe I have a right not to eat broccoli under some penumbra of the privacy thing, but I can sure make you buy it. So I'm making 2 points. One is, again, the no limiting principle point, but this is unique in our jurisprudence. Every other person that's been regulated under the Commerce Clause is an impediment to the congressional scheme at the intrastate level, and I agree. They've abandoned the distinction between interstate and intrastate given how related those markets are today. Terrific. But what they haven't done is said if somebody's not engaged in commerce at either the local level or the national level, somehow they're within Congress regulatory reach. They can get at local bootleggers whose liquor never crosses state lines. The question on this case is, can they get at teetotalers? Can they get at people who have decided, I don't want any part of the liquor business? Well, you know what? You're really going to help the liquor business if we start making you buy wine that you don't want, because that subsidizes them for all the taxes we impose on them. Go ahead.
Here's the problem with that. When Mike sits in his living room and doesn't buy insurance, he is actually doing something that affects the national economy. That's what the government is saying. That's what Congress said, that the failure to buy insurance is different in this circumstance than other things. That because everyone could get, this is Judge Sutton's point in the Sixth Circuit. He says, well, let me just finish and then you can interject.
Very much on topic. I just want, but why does that give rise to a limiting principle? The problem in 2008 was that people were sitting in their living room and they weren't buying cars. That was the problem.
Here's the difference. What Congress is saying, what Judge Sutton is saying, is health care is different than the buying of cars. Everyone is going to need health care, and those costs are externalized on people right now. Now, maybe you can make that argument with other markets, but I don't quite think so, because, as Judge Sutton said, you can't predict when you're going to get struck by cancer or a heart attack or get an appendicitis. You can budget for things like buying the cars or other things, buying broccoli, whatever. This is something that, wait, wait, Paul, let me just finish. This is a product that everyone is going to buy. And what Congress is reacting to is Congress is reacting to is not the failure to buy, it's the failure to pay for it. Health care is inevitably going to be consumed by everyone, including Mike as he sits in his couch on the living room. And Congress found that those costs aggregated mean that each American family spends $1,000 per year extra, and that is across state lines. Now, maybe you can tell that story with some other market, and we'll deal with that case then, but I don't quite think so.
But Neal, my question is just, even if you're right, and we could debate the factual premise to a fairly well, but even if you're right, that the healthcare market is different in that respect, why does that suggest any limiting principle? It suggests why this might have been the first market that Congress regulated. But if the Supreme Court accepts the government's argument, which is you can regulate this under the commerce power because the decision not to purchase health care has a profound impact on the health care market, why does the fact that everybody purchases health care mean that the next time Congress tries to do this with the exact same theory, which is people's failure to buy a product, is really making it a pain to regulate that particular market, so we're going to make you buy that product? The next time, it'll be cars. Some people don't buy cars. They walk. Why is that going to make one bit of difference under the structure of the Commerce Clause argument that the government's making to the Supreme Court?
Because, Paul, I think what does the work in your argument, and you are truly the best lawyer of your generation, and if you can't win this case, no one can, but I don't think anyone can, because of the following thing. Because the power Congress is seeking here, what does the work in your argument is Congress is forcing someone to buy something that they wouldn't otherwise buy. But what the Congress is saying is no, everyone's going to buy health care. They're going to use health care, they're going to consume it. So what they're doing is regulating the financing of it. Now, I think the court can easily write an opinion that says health care is a market that is different potentially than any other market because of that and because of the demonstrated costs that occur across state lines. Now, if you can tell that about some other market.
There are two limits. Healthcare is very distinct because everyone needs to have it and will have it at some point in their lives, and that's not true of other things. And here's the second limit, which we keep saying, they just don't want you to hear it, but I want you to hear it. It has to solve an interstate spillover problem. There are cases which the Supreme Court said Congress went too far. It established a limit, and we are on the correct side of those cases. Lopez and Morrison were cases where there was no interstate problem. People in one state weren't imposing costs on those in other states, and Congress therefore had no power to regulate because it wasn't an interstate problem with people in one state imposing costs on people in another state.
Let me ask you all to respond to this version of the argument, and that is, what Congress is doing is saying that you can't pay for health care with your own money, that you are going to have to pay for it with insurance. That when Michael says you make a rational economic decision not to buy health care, he's talking about an economic choice that is being made by individuals. And that fundamentally, unlike the decision to be a teetotaler, which might be a moral decision or something like that, that the decision not to use insurance but to self-insure is what's being regulated by Congress here. And is that a limiting principle?
No. Because they could require you to compel every time you decide not to buy a product, whether it's contraceptives covered by the health care or books in a school curriculum or any other kind of traditional thing we think. Well, no, I'm just, but I'll make it a purely economic. If you want to make it purely economic, I will. No, cars are an economic, or then I don't understand your question.
All right, I apologize. Okay. So you're going to buy health insurance is the premise of the statute. Okay, I'll get through two sentences. Right, and as I take it, the statute is saying is that, no, it's not even one yet. Is that you're going to buy it, now we're going to tell you how you're going to buy it. You were going to pay for it yourself, now we're saying that you're going to pay for it this way, through insurance, which is different from telling you how it is that you have to buy health care. It's saying when you get health care, you're going to pay for it with insurance rather than on self. Yes, so why isn't that different from saying you have to go buy a car?
I'd rather, my transportation needs are solved by my feet. I've decided to self-move, or a scooter, or a cab, or an airplane. Well, we're just telling you which way you've decided to engage in transportation. It's not a limiting principle. This is the only market that most Americans are going to go into, is that right? Food, clothing, transportation, housing, communications, the labor market. Everyone's going to go into the labor market, so under their theory, they could start regulating college freshmen because it's quite predictable that 95% of them are going to enter the labor market. I can't think of a more constraining, limiting principle on Congress. And if Akhil uses the word interstate one more time, I just want to make 2 points. 95% of guns travel through interstate commerce. That was Lopez. That was about as interstate a market as you could get. That wasn't the theory that it didn't have anything to do with interstate market. It didn't have anything to do with economic activity. And economic inactivity has even less to do with economic activity than the gun purchase in Lopez. And will they defer to Congress on what an interstate market is? They've already held, in Paul's case, Raich, and in Wickard, that growing wheat for your own crops on your own land and having marijuana in your own basement for your own medicinal uses affects the interstate market. And you know what? They were probably right. Because I don't know how you distinguish between homegrown wheat and homegrown marijuana and interstate marijuana. And by the way, it would create enormous enforcement difficulties. So if their limiting principle is rationally establishing a nexus to interstate commerce, we lost that battle in the 1930s when Wickard was decided.
This is why I think your Lopez example backfires, because our point is that Lopez demonstrates the precise limits that in Lopez, the states were separately competent to deal with guns. They can enact any number of regulations that there's no spillover effect when an individual state deals with the gun problem. By contrast, healthcare is one in which when one state does it, it causes interstate spillover effects. Now, if you can tell that story about your transportation markets and your food markets and the like, in which food expenditures are predictable and neighbors don't get stuck the same way with bills they are in the healthcare market, then maybe if Congress can tell that story, that may be something that is constitutional down the road. But
legislative genius to come up with an interstate food market theory. But if I can just try, you started this, Neal, I'm sorry, you started this by saying we're all modeling this after Massachusetts. The Massachusetts miracle, the thing that worked perfectly. So by your own definition, it's not a problem that you can't solve at the state level. You're all holding up, building a cathedral about the Massachusetts.
As Massachusetts itself told the courts, their solution didn't work effectively precisely because it wasn't a national solution.
Precisely because you can't have your cake and eat it too. What you can't do is tell people
maybe
who...
you know more about Massachusetts than they do, but...
Look, let's see if anyone disagrees with this economic rationale. If fire insurance companies have to insure people after their house is burned down, is that going to raise premiums? Yes. And it's the same thing if you have to insure people who are already sick for health insurance. I'm not saying it's a wrong charitable decision to make, but the notion that that won't drive insurance premiums through the roof is crazy. It's called the Patient Protection and Affordable Care Act. The patient protection was protecting sick people against this discrimination by insurance companies. What made it affordable was conscripting healthy individuals to offset the insurance premiums that the insurance companies suffered because of.
Great, Mike. You don't like the act, vote against it.
It has nothing to do with politics. What it has to do with is your false assertion that this is somehow a unique factual scenario where Congress is never going to be able to cobble together an interstate nexus analogous to this. Every time somebody doesn't pay somebody, costs are shifted. Either the seller absorbs the cost or his other customers absorb the cost. It's not a limiting principle.
Let's talk about
and you're just pretending otherwise because you know there's no limiting.
Let's talk about Massachusetts and cars, and I will not use a certain word that begins with inter and ends with state. They want you to think that there's something distinctively dangerous, problematic about the mandate to buy a good from another private supplier. How do we test that idea? Because we don't see in the case law any particular concern about that. They've come up with that, but we won't find that in any Supreme Court case that they've cited. It's not in the Constitution that that's a special concern. It's exactly like The argument in McCulloch versus Maryland, the opponent said, well, you're creating a corporation, and a corporation is somehow very bad, and what's the limiting principle? And John Marshall says there's nothing particularly problematic about a corporation, just like there's, I say, nothing particularly problematic in principle about a mandate to buy a private good. How does Marshall, hang on, how does Marshall prove that?
Give them their due. They would say that there isn't a big concern about this in the case law because there has never been a statute that required somebody to purchase something.
And let's take Massachusetts and cars. Every state requires you to get insurance, almost every state, before you go on the road, because otherwise you are exporting costs on other people. That is a mandate to purchase insurance. It's at the state level.
But
and hang on, and this is proof of the following point. Hang on, that there's nothing violative of the Bill of Rights, nothing particularly problematic about this. States do it all the time. They do it for cars. Massachusetts does it. Connecticut does it. Because otherwise, when you drive uninsured, you are imposing risks of costs on other drivers. So that proves that there's nothing wrong, and that's not just true of car insurance, it's other insurance too. States do it all the time. Now,
look, their point, as I take it, is that this is something that the state should be doing. And I don't think that they're going to be persuaded. They're not going to be persuaded anyway, but I don't think they're going to be persuaded by saying, well, states do things like this. Is there a federal statute, to give them their due, is there a federal statute in the history of the Union that required you to purchase a product?
Yes, I read it to you. It's the Militia Act of 1792, and it's a
you could have been given the guns, right? You weren't required to purchase.
You don't have to purchase this too. You can actually be given a health insurance policy. It's exactly the same logically all the way down, and I'm making a twofold point. One, there's nothing wrong in principle with government, forget state or federal, government requiring you to buy something. Our governments do that all the time. There's nothing distinctively wrong in principle about that. Now, the federal government can't do everything that state governments can do. It's limited in certain ways, and that's where the word that begins with inter and ends with state comes in. So there's nothing wrong with a mandate. That's what we know from insurance for cars and every state and all sorts of other mandates the states have. And now the only question is whether that very traditional governmental tool that's been in operation for 100 years is a sensible tool to deal with the distinctively federal problem, an interstate problem created when basically people in one state are, as a practical matter, imposing costs on people in other states, or people are afraid to travel interstate lest they fall sick, and so on. That's the interstate problem to be solved with this traditional regulatory tool.
Tom, I'm well. How are you? Would you like me to respond to the Militia Act of... I mean, I'm happy to.
No, on the question of whether there's a limiting principle, I take it that you agree that Congress could have done this if it were forthright about it being a tax, right? Absolutely. And I also guess that
I don't, by the way, but go ahead.
Okay. Noted. I also guess that you agree that Congress could require that before you actually consume health services, you acquire health insurance, that at the point of sale, you're going into the hospital, that sort of thing. Does that cut against the concern about there not being a limited principle if you believe that Congress could accomplish the same thing through other means?
No. I mean, it suggests that there is a limiting principle, and the limiting principle is you can't do this through an individual mandate. It suggests that there are, in fact, other ways that would be more politically accountable for Congress to accomplish these objectives, which I think is important because, you know, there's a whole health care policy debate that, you know, I'm happy to wade into to the extent necessary to argue this case, but it's really beyond my ken. There are people who are talking about the health care market and have, you know, dedicated their whole lives to studying health care, and to the extent they honestly believe that this series of requirements is necessary, they should take great comfort from the fact that there is a way for Congress to accomplish this. It may not be politically doable in the short run, but there is a way to do this. And it's just you can't sort of have the shortcut of the individual mandate. And I think that's, you know, that's a really important principle. And just to sort of make two kind of points that are complementary to that, but respond to things that have been said. One is, you know, it really is important to distinguish between the mandate and the penalty. Because it's true, if you decide that you're not going to buy health insurance, you will pay a penalty if you are not exempt from the penalty, and a lot of people are. That shows how different they are. And that's something you're going to have to do on April 15th, and you'll be reminded that this is, the federal government doing this, and that will hack you off. But you don't pay the premium, which is really what Congress wants. They don't want you to go the penalty route. They want you to get compliant health care. And when you do that, you're not going to write a check to the IRS. You're not going to do it on April 15th. You're going to write a check to an insurance company. And to the extent that that's really a tax, then it's really pernicious. Because when we try to figure out this huge budget mess that we have in this country, we're going to start by looking at what are our tax revenues and what are our government expenditures. And it's really pernicious to have something that's really a tax that's going to be completely off that budget. It's going to be, in fact, people are taxed to whatever level they are, and then they're forced to buy this product that they don't want. But if they're forced to buy it, they might as well have it, as opposed to not have it and then have to pay a penalty that's basically as large as what it would cost to get it. And so you're going to have this whole thing kind of off budget. And that's something that's very unaccountable, and I don't think the framers had in mind. The second thing is just...
They call it a tax? Have you just... So
No,
even if they call
no, no.
now it's unconstitutional because you end up buying the insurance instead of paying the tax?
If you call it a tax, then as Michael suggests, it's going to be distributed in a different way, more broadly, because I don't think Congress is going to pass a tax. I'm not sure they could. That's limited to healthy 29-year-olds. But even if they did, then at least it would be on budget, and I think that would be better. Second point I just wanted to make is I can't resist saying something about the Militia Act of 1792, because I do think it's different, which is, first of all, Congress was given specifically the power to raise a standing army, and I think it could certainly be argued that the Militia Act was an act pursuant to that power. That's important for two reasons to me. One, Congress was given the power to raise armies. They were separately given the power to regulate them. And it was recognized in the Constitution itself that those were separate things. And the power to raise an army was very controversial. It gave rise to the Second and Third Amendments to the Constitution. The power to regulate an army, once it was raised, was not controversial at all, because nobody wanted an unregulated army. By contrast, if you look at the Commerce Clause, all it does is give Congress the power to regulate commerce. And so I think it's fair to say that it assumes that there was actual commerce ongoing, that Congress then had the authority to regulate. That was a power, I think precisely because it assumed the commerce to be regulated, that was not controversial at all. And I think if you go back to the minds of the framers and you posit the idea that they really thought that the Commerce Clause was as broad as it is, and that it included the power to compel people into commerce in order to regulate them, then our whole constitutional history would be different. Instead of having the Second and Third Amendment that responded to the power to raise armies, we would have had the 11th, 12th, 13th, 14th, 15th, and 16th Amendment, at the framing in order to control this really broad, potentially dangerous power to compel people to engage in commerce.
All right, I want to give Neal the chance to put in a response or further thought, and then I want to make sure that we have time for questions.
So just briefly, of all the arguments and criticisms against the act, the one that there's a lack of political accountability, that this act somehow stole into the unsuspecting night, seems to me the weakest. I think Paul's concession here, which I understand why Mike won't concede, that if they did it with using the word tax a few more times or something, that would be constitutional, really cuts the legs out from under them when it comes to this whole point about unlimited government and the like. I mean, their concession is that as long as they do it with the word tax, I guess more than 32 times in it, in the act, that somehow that makes it constitutional. And now we're just haggling over really how many times they have to say it.
I'm not saying you could have an individual mandate just if you labeled it a tax. I'm saying you could accomplish the same objective by raising everyone's taxes and providing a direct subsidy to the health insurance industry. And you'd end up with the exact same public policy result, which was you'd have guaranteed issue, you'd have community rating, and you'd have everybody paying for it. I'm not saying it's just labels.
Oh, okay, then I misunderstood you. So
You're arguing that there's no difference between requiring people to do something directly and creating the financial incentives to do so. I assume the government's going to concede error on the Medicaid thing, because their entire argument on Medicaid is we're not forcing states to do it, we're just giving them strong financial incentives to do it.
That has to do with very different state-federal relations, but I'll maybe defer to questions.
Terrific. So we have 20 minutes left. Let me make sure that we have the opportunity to ask questions. And I think before Nina has a question, but I think we have microphones available. Here we go. So if you'll just bring it around, please. And if, just because folks can't see you as well, if you could just introduce yourself.
I'm Nina Totenberg from NPR. I have two questions that have not been addressed by this rather lively debate. The first is, is the question of if this is a tax, if it's collected by the IRS and can be characterized as a tax, then why is it not, in fact, covered by the Anti-Injunction Act, and therefore putting the case off until 2015 or something like that? And my second question is whether I would like you each to, or at least one of you from each camp, to address the question of severability and why, if you lose any part of this case, the rest of the statute should stand or should not stand.
Okay, so on the Anti-Injunction Act, let me ask Neal first. Is that okay?
You can. I don't remember all the details
Sure.
of the Anti-Injunction Act, so it might be better posed to those two.
Well, I'll take a stab at it. I mean, the first problem with the question is, you refer to it as it. But it's important to, again, to distinguish between the mandate and the penalty that enforces the mandate. The penalty that enforces the mandate does look a little like a tax. It's what's collected by the IRS. But the problem is the challenge focuses on the mandate. And the mandate, most people, I think if they were rational, if the mandate's constitutional, they're not going to stubbornly say, well, I'm not going to buy health insurance anyways, because the tax penalty, the penalty, is sort of keyed to the amount of the premium you would otherwise pay. And so I think most people are going to make the rational choice that if I have to buy insurance or be assessed an equivalent penalty for not buying insurance, in which case I'll pay and I won't have insurance, well, I might as well get insurance. So people are going to pay. And that's what Congress wants them to do.
Right, but Paul, I think the question asks you to assume none of that's right. So assume that the statute is upheld under the taxing power. Does it then run into the Anti-Injunction Act?
Well, okay. I mean, I'm just trying to explain more broadly why I don't think the Anti-Injunction Act is a problem. It's not a problem because the principal challenge is to the mandate. And that creates an important difference for purposes of understanding the Anti-Injunction Act. The Anti-Injunction Act is not a crazy piece of legislation because it basically says, look, if you're a taxpayer and you're hacked off about a tax and you think it's unconstitutional, you have an option that most people don't in most litigation. Most of the time, you face an obligation from the government, and your choice is to either comply, in which case you can never sue, or you can bring a pre-enforcement challenge and say, that's unconstitutional, don't do that to me. In the tax context, it's different. I can pay the taxes, and then I can go get a refund, and then I can litigate that way. That doesn't work for the mandate, because once I pay my premiums to the insurance company, I can't go seek a refund from them. It doesn't work that way. So the Anti-Injunction Act is really a non sequitur for the mandate. But even if somehow it's a tax, there's still reasons why the Anti-Injunction Act wouldn't apply. And one of them, I'll give you two, and there are probably others. One is, there's a long line of Supreme Court cases interpreting this thing that don't interpret it in a way that make it seem jurisdictional. They make it seem like it's basically a defense that the government can raise, but they can also waive the defense. They've created exceptions. And if the Anti-Injunction Act is not jurisdictional, then it doesn't matter here because the government and the private parties and the states all agree that the Anti-Injunction Act shouldn't apply. So they don't even have to reach the Anti-Injunction Act if the court all agrees that it's non-jurisdictional. The other thing is, we have arguments, and I won't belabor them, but we have arguments as to why the Anti-Injunction Act wouldn't apply to the states no matter what.
Okay, so then the second question is, if the individual mandate goes down, does the rest of the statute logically have to fall apart?
So the government has taken the position in this case that if the individual mandate falls, only a few provisions of the Act fall. That is the insurance market reforms on guaranteed issue and community rating. And their theory is exactly what I outlined right at the beginning of our hour together, which is that the reason why the individual mandate was put in was to deal with the adverse selection problems from the community rating and guaranteed issue provisions in the Act. Some folks have come in and said, well, the whole 2,400 pages of the Act has to fall, including things like funding for abstinence education and the like, that I think many people think is a very tough argument to have the entire Act fall. It's true that there is no severability clause in the legislation, and so that's what gives that argument to some teeth. But I think the court has said a few times that the absence of a severability clause alone isn't dispositive.
And what position have you all taken on the question of what falls apart if the mandate goes down?
Precisely because Neal's right, that I don't think any reasonable people can disagree that the individual mandate is tied inextricably to the what we call guaranteed issue and community ratings provisions. That is the heart of the Act. It's called the Patient Protection and Affordable Care Act. The two provisions that gave the patients the most protection were the guaranteed issue, and no ban on pre-existing conditions thing, and the thing that made it affordable, again, was the individual mandate's massive subsidy. So once you've taken away both pillars of the entire Act, once you've ripped the heart and lung out of a body, it doesn't matter if the fingers can continue to actually move. What matters is if they can move in the way that Congress intended. And there's no way, when the two basic pillars of that Act are ripped out of it, that you could possibly say the rest of the Act is okay. I suppose you could take the anti-competitive provisions out of the Sherman Act, and you could still have an antitrust division at the Justice Department, which could function, but what it couldn't do is function in a manner that Congress intended. And this is particularly true of this Act because we know that it was a series of compromises, and pulling out any one part was going to doom the whole. Surely if you pulled out the biggest part, it would doom the whole.
An even more modest view of severability would be, rather than killing the whole thing or even the heart and lungs of it, would be to say, well, if it's all about the fact that they used the word revenue rather than tax, then the Supreme Court could simply say, since if it did say tax, it would be obviously okay. We, in effect, rewrite the statute so that wherever it says revenue, it says tax, and people now have, there's a political accountability, and you might say, well, that's really weird, but that's what the Namundo case did, and other cases have basically, in effect, Marbury versus Madison. The statute doesn't have a severability clause, and Marshall, in effect, just rewrites one clause of Section 13 of the original Judiciary Act of 1789. So you could have if the whole point is people need to understand it's a tax, the Supreme Court can make that clear. And by the way, Paul said one other very important thing. We talked about individual mandate, but he said, strictly speaking, you don't have to buy the insurance. You can simply pay instead. And when you do, you have not violated the law. You're not a lawbreaker. If you choose for philosophical or other reasons not to buy the insurance, that's fine. Then just pay the man.
True. That's the way. Yeah. And the statute is actually structured in such a way that paying the penalty is not compliance with the mandate, and the mandate continues, and you are under a federal mandate. And you can say that, well.
And just strike that part down. Read the statute so that it's clear that as long as you pay the man, you pay the penalty, you're in compliance. If that satisfies everyone, that's a very nicely small, severable holding.
It's not a labeling issue. I don't care if they called it a tax, a penalty, or a banana. What it is a mandate to do something, and if you don't do it, you are in violation of federal law. They attach a monetary penalty to that. That's not a tax. If they banned cigarettes in the United States tomorrow and said the enforcement mechanism is a $4 penalty for every pack you sell, everyone in the world knows that's different than a $4 tax on a pack of cigarettes. And the government conceded that if there's any distinction between a tax and something else, it's that it's not a payment for an unlawful act. And we all understand why that is so. If in Lopez, for example, they had said you can't have guns within 1,000 feet of a school, and the penalty when you do it is a purely monetary penalty, could Congress just have said that's a tax? No, because they have made the act of having a gun near a school unlawful. And it's not only from the citizens' perspective does this make sense, it's from Congress's perspective. Congress doesn't want anybody to pay this penalty. They want them to buy insurance to solve all the problems that these folks have been articulating all morning. So it doesn't work from their perspective if you have massive noncompliance, which is why they mandated the purchase of insurance. It's not semantics. It's a fundamental distinction between being a lawbreaker and being a person who complies with the law but decides to pay their taxes.
All right.
The government's position,
and you are, I'm sorry.
Russell Mulkyber, the government's position is that to reach its goal of universal coverage, it's necessary to require people to buy private health insurance. Earlier this week, 50 medical doctors who support single payer filed a brief in this case saying that they believe that this mandate's unconstitutional because the government missed an alternative, which is single payer, which most Western industrialized countries have. And I'd like to ask both of you gentlemen what you think of that argument.
Look, I'm a libertarian, but unfortunately, I don't think the Supreme Court should judge the validity of congressional action by whether it's more or less libertarian than options, particularly options adopted by Western Europe. They should ask themselves the legal question, is this regulating commerce among the states? And since for all the reasons we've already articulated, it's not remotely involving commerce, much less commerce among the states not to buy a particular product, then that should be the decision. I think the policy alternatives to Congress are completely irrelevant to this decision.
Well, but
that the single...
to the extent there are other options, including single payer, that might be scored differently by the American Libertarian Association or something. But the fact that they're doable, I think, is not irrelevant because they just show this is not an insoluble problem that this is the only way to go. This is one way to deal with it, and it just happens to be an arguably unconstitutional way to deal with it, and we'll get the answer to that.
I'm sorry, just to clarify, and I want to echo what Paul said. Look, if the argument is they could have just called this a tax rather than commerce, then my question to them is, well, then what's the big deal? Who cares if we win on the Commerce Clause? You should grant us this power because it's not going to handcuff Congress's ability to achieve your policy objectives. So really what you're saying is this is just a do-over for Congress, and this time they've got to be honest with the American public during the legislative process and say this is a tax. What's the big deal? Then you can solve it. I don't happen to believe that, but if that's their position, then that would seem to me to be a strong strike against their argument, not in favor of it.
Okay. Other questions? Anybody?
What's the basis
Who
for
are,
the?
I'm sorry.
I'm sorry. I'm Barbara Perkins. I'm in CRS. What's the basis for the argument that it's that the mandate's unconstitutional if there's not a limiting principle?
The court has made clear that obviously you need to go back to first principles. The federal government is inherently different than the states because the federal government is one of limited enumerated powers. If you interpret the commerce power to essentially give them the breadth of power that the states enjoy under the police power, that by definition shows you, standing alone, that your interpretation of commerce must be wrong because the framers never would have given them a power that's at least equal to, and I would argue much greater than the commerce power, i.e. the ability to compel commerce when they were regulating commerce. I start with the text and say this is not regulating commerce. And by the way, even if there was any ambiguity on that, we know they've got to be wrong because, as if anything is vividly proven this morning, there is no limiting principle. The only limiting principles are Congress can treat citizens like they treat militias, which is not a whole lot of a limiting principle, and the Bill of Rights would prevent a state from doing this, so it prevents the feds from doing it, but that just means the feds and the states have precisely the same power. So that's why this limiting principle conversation is so important.
Well, as the court has also said, though, you shouldn't get too hung up on whether there's a limiting principle or not. From McCulloch to the repudiation of Lochner, the court has said repeatedly that as long as it is within the enumerated power, as long as within the means, that as long as the ends are legitimate, is the means are what the court will defer to Congress in. And so, yeah, you could say there's no limiting principle after the minimum wage was passed. Why not have a $5,000 minimum wage and punish it if you don't pay it by the death penalty, or something like that? And yeah, you can come up with absurd examples for every exercise of government power. Every government power can be taken to the extreme. The question is, do you really want the federal courts to be adjudicating these questions on the basis of absurd hypotheticals. And I think the court has said from McCulloch on, no, absolutely not.
And you can do the same thing with the income tax. Well, boy, if you can have a small tax, why not a big one and not a ridiculous one? And the limiting principle, we do not concede that there's no limiting principle. Mike said that. I emphatically disagree. He just won't, he doesn't want me to keep repeating it. The limiting principle is there under the Commerce Clause, which is about commerce among the states and with foreign nations, that the Congress has to be legitimately trying to address a genuine problem between the states where no single state can actually solve the problem on its own because of spillover effects of one state's policy on other states, positive or negative. You try to give insurance to the people in your state and health care, and you become a welfare magnet. So there are certain things, that's why we have a federal system for unemployment insurance to deal with the welfare magnet problem, and for certain Social Security and other things, workers' compensation. So the limiting principle under the Commerce Clause is that Congress has to actually be trying to address a problem that the individual states are not competent to handle on their own.
Okay.
Hello, I'm Mark Thronson. I would just wonder if you could comment a little bit more on Wickard versus Filburn, because when I was in law school in the 1980s, we spent a lot of time talking about that, and I don't remember ever talking about no limiting principles other than interstate political constraints in Bill of Rights. So I'm just curious, how is the Supreme Court going to decide that based on its precedent?
There's an obvious distinction between regulating small producers of a product and if Congress had passed a law in the 1930s, instead of telling Mr. Filburn he couldn't grow wheat, if they required every American to buy wheat. That would have solved the problem a lot more directly than harassing poor Mr. Filburn. That would have done exactly what they wanted to do, was, in that case, drive the price up. So the fact that Congress has never done this before, even as Paul points out, in times of extreme national emergency, standing alone is a pretty good indication that they've never had the power. And again, the difference between Mr. Filburn and my clients is, again, the difference between a local bootlegger and a teetotaler. It is a far greater intrusion on individual freedom. It is far more remote from the commerce power to require somebody to purchase a product than to limit their production of that product on an intrastate basis.
So I think, as Judge Sutton said, in both Wickard and in Raich, these were situations where people were not doing anything at all. They were, she was not engaged in interstate commerce while she was trying to grow marijuana in her backyard. There was no commerce whatsoever. But what Justice Scalia said is, as long as that regulation on marijuana was part of a comprehensive national solution, then it would be constitutional. And here, I think the same argument applies, the same structure of the argument applies, that this is one part, the individual mandate, of an overall reform to the health insurance markets, and is constitutional, and that you can't slice and dice and look at one half of 5000A and say, well, that little provision is unconstitutional. You have to look at the overall structure, figure out what Congress is reacting to, and defer accordingly. That's what the Supreme Court has said from McCulloch on, and that's why I think they have an extremely hard case.
And since you went to law school, the three most relevant cases that you've heard all of us talk about are, on the limits are Lopez, Morrison, and Raich. And when you put these three together, I think they stand, and we accept all of these. We just think we're on the correct side of these cases. They basically draw the line between Congress trying to solve a problem that really does spill over across the states, an economic problem, and Congress can regulate that, and that's Raich, because there really is an interstate market in drugs, and situations where Congress was intervening and there was no interstate problem to be solved, and that was violence against women and guns in schools, the Lopez and Morrison cases.
I mean, sure, in response to Neal's comment, which, I think very well captured the government's position, and it's, the government sort of likes half of Justice Scalia's opinion in Raich, the half that sort of talks about, sort of if it's one part of solving a bigger problem. And we have our responses to that, which is, there are other statutes, or other cases like Prince and New York against the United States, when the court hasn't hesitated to stop and strike down one part of a broader statute that it didn't question. But I think it's important to focus on the other part of Justice Scalia's opinion, which is, he basically recognized that what the government was doing in regulating Angel Rach's conduct involving marijuana was not regulating commerce at all, and that it was necessary and proper to their regulation of interstate commerce. And so his case rested on the necessary and proper clause, and that's the other third clause that you're going to hear a lot about in these arguments. We focused on commerce and tax, but necessary and proper is also going to be at issue. And I do think, that way of analyzing it, that half of Justice Scalia's opinion, I think is quite helpful to the challengers in this case, because I think if you focus on the fact that when somebody is in their living room, they're not engaged in commerce. And so the question is forcing them into commerce to more efficiently regulate commerce and effective and appropriate use of the necessary and proper power? I mean, I think in some ways that is the question in this case. And I think there's a very strong argument that, that it may not be necessary, but in all events, it's not proper. It is simply not a proper exercise of Congress's limited and enumerated powers to force somebody into commerce to better regulate them. It's very analogous to Justice Scalia's own reasoning in the Prince case, where he recognized, the interstate firearms market was something Congress could regulate, but it wasn't necessary and proper to force state officials to be commandeered into the regulatory scheme. And I think there's really an analogy between that and what's at issue in this case.
Prince and New York are not Commerce Clause cases, and I think that Paul's essential problem is that when you're sitting in your living room, you are, Congress found, affecting interstate commerce. You are shifting risks onto other people. Health insurance companies, hospitals, et cetera, are all creating infrastructures to deal with the problem that you can't predict when you're going to get struck by cancer or a heart attack or the like.
Okay. Thank you. I really appreciate it. And thank you all for coming.